Good morning. I'm Gary DeWaal, and this is Bridging the Weeks from March 18th through 29th, and today is April 1st, 2019. Not the spoofer, but the person alleged to have developed the computer program used by the spoofer to conduct his illicit transactions goes on trial this week in a criminal action brought by the Department of Justice. Last week, the presiding judge declined a request by the government that the jury be authorized to convict the programmer should they solely find that he likely suspected the program would be used for spoofing, even if he never learned definitively from the spoofer that, in fact, that was the purpose. Separately, two food giants agreed to settle the Commodity Future Trading Commission's enforcement action against them, alleging manipulation, attempted manipulation, and fraud-based manipulation in connection with their 2011 end-of-year trading of wheat futures on the Chicago Board of Trade. No terms have been announced, however. I am back from a week in Colorado where I did not ski, but nevertheless enjoyed mountain views, helping my wife make her first snowman, and some good snowshoeing, so I could acclimate myself to the warmer climates in New York City and enjoy the beginning of the baseball season. Let's get started. Jitesh Thacker, who was criminally charged in early 2018 with conspiracy to commit spoofing and aiding and abetting spoofing in connection with his alleged development of a computer program known as NavTrader, used by Navinda Sarao in connection with Mr. Sarao's spoofing activities between April 2010 and April 2015, will stand trial this week in a federal district court in Chicago. The trial will occur after Mr. Thacker prevailed last week in a motion to preclude the government from suggesting to the jury they could convict Mr. Thacker if they solely found he had a strong suspicion that NavTrader would be used for spoofing, but he purposely avoided learning that fact. Instead, the government will have to show Mr. Thacker possessed knowledge of Mr. Sarao's illicit purpose beyond a reasonable doubt. The instruction proposed by the government is known as a quote-unquote Ostrich instruction. According to court papers filed on behalf of Mr. Thacker, the government first proposed the court's use of an Ostrich instruction on March 22, 2019, 6 days before jury selection was to commence in connection with the defendant's trial. Mr. Thacker's court papers allege this was because of, quote, the government's realization that they don't have sufficient evidence to prove Jitesh's knowledge beyond a reasonable doubt, end of quote. In case you forgot, Mr. Sarao pleaded guilty in November 2018 to criminal charges previously brought against him by the Department of Justice for allegedly engaging in manipulative conduct through spoofing-type activity involving E-mini S&P futures contracts traded on the Chicago Mercantile Exchange between April 2010 and April 2015, including illicit trading that contributed to the May 6, 2010 flash crash. On the same day, the Commodity Futures Trading Commission announced that Mr. Sarao settled civil charges that it brought against him and Nav Sarao Futures Limited PLC, a company he controlled, related to the same essential conduct. It's good that the judge presiding over the Thacker case will not impose a principle of absolute liability on a programmer for the illicit acts of his customer. Let's see, however, what the jury does with this case before reaching any final conclusions. UBS AG and Goldman Sachs International will find a collective 61.3 million Great British pounds, approximately 80 million US dollars, by the UK Financial Conduct Authority for transaction reporting failures over a multi-year period. Goldman Sachs International was sanctioned 34.3 million Great British pounds for problematic transaction reporting from November 2007 through March 2017, while UBS was penalized 27.6 million Great British pounds for transaction reporting through approximately the same period. New reporting requirements across Europe went into effect on November 1st, 2017, as a result of the implementation of the Markets and Financial Instruments Directive that changed the list of transactions that needed to be reported and standardized the type of information that was required to be reported in transaction reports. According to FCA, both firms failed to accurately report a large number of transactions during the relevant time, failed to report other transactions that should have been reported, and inadvertently reported some transactions that should not have been reported at all. FCA said that Goldman Sachs International sustained issues in reporting because at various times it purportedly did not ensure it had sufficient change management procedures and controls, quote, to manage the impact of business or upstream system changes on transaction reporting, end of quote, did not have sufficient processes to detect transaction reporting errors on a timely basis, and did not have adequate systems and controls to accurately reflect counterparty reference data used for transaction reporting. FCA alleged that UBS also had breakdowns in change management controls and the maintenance of static data, as well as errors in its systems, technology logic, and reporting processes. Both firms benefited from 30% discounts to potential penalties under the FCA sanctioning regime because, among other reasons, FCA recognized they identified many of their own errors and proactively took steps to correct the reporting breakdowns. Although reporting obligations are more extensive for European-based financial institutions under MiFID, the Commodity Futures Trading Commission imposes substantial reporting obligations on U.S. swap dealers. Fines for violations have also been substantial for violators of these requirements in the U.S. Beware. And finally, Kraft Foods Group, Inc. and Mondelez Global LLC entered into a quote-unquote binding agreement with the Commodity Futures Trading Commission to settle the CFTC's 2015 lawsuit against them, which claimed that wheat future trades the defendants entered into during November 2011 on the Chicago Board of Trade for the alleged purpose of hedging were in fact entered for the purpose of artificially lowering prices in the related cash market. This activity, claimed the CFTC, was a violation of federal law and the Commission's rules prohibiting manipulation, attempted manipulation, and fraud-based manipulation. The CFTC also charged the defendants with violating speculative position limits as well as non-competitive trading in connection with multiple transfers of positions between different accounts that were executed as exchanges for related positions instead of as transferred trades. No terms of the settlement were announced. The parties are obligated to report back to the federal court in Chicago, hearing this case for a status update on May 28, 2019. Well, that's it for this week's edition of Bridging the Weeks. As always, there's more information in each article and more articles on the article version of Bridging the Week at www.bridgingtheweek.com. Check it out. I'm Gary DeWaal. Have a great week. Until the next edition of Bridging the Week, take me out to the ball game. Ciao.